segment, the operator will provide instructions for those who wish to be in the queue to post a suggestion to the speakers. Also, during the entire session, participants will have the option to submit written questions and suggestions through the chat box feature. This is the Q&A box that appears to the right of the slide deck on your screen. The staff from the CIS Ombudsman's office will review your questions and suggestions, and where appropriate and as time allows, our speakers will address them during this webinar. We will work and look at every single one of the questions submitted and determine if there is something more that we need to do to address concerns arising from the stakeholder community. If your question is not answered today, please feel free to email it to our office at cisombudsman.publicaffairs@hq.dhs.gov. After today's webinar, we will post the full list of questions, comments, and answers addressed during the engagement. If you wish to access the summaries and materials from our past webinars, please visit the CIS Ombudsman's website at www.dhs.gov/outreach. Thank you all for joining us today. Now it's my pleasure to introduce CIS Ombudsman Phyllis Coven. Phyllis, the floor is yours.
Thank you, Bertha, and good afternoon, everyone. It's really an honor for me to serve as the 7th Citizenship and Immigration Services Ombudsman with the Department of Homeland Security. As some of you may not know, the CIS Ombudsman's Office was created by Congress as part of the Homeland Security Act of 2002, almost 20 years ago, and given a rather unique threefold mission. First, we serve as an office of last resort, and through casework services, help individuals and employers who need to resolve what is usually an exceptional processing problem with USCIS. Second, like today, we provide an ear to the public and try to engage with the full range of stakeholders, all parties who are invested in the immigration system, individuals, employers, really all who have concerns. Our particular focus is on helping to resolve and to identify access and administrative processing challenges associated with USCIS and USCIS systems. Our casework and stakeholder activities inform our third and most paramount or most public program area. We make recommendations, both formal and informal, to fix systemic issues in the delivery of immigration benefits and improve the quality of services provided by USCIS. Although we work closely with USCIS throughout the year, our most important studies culminate in the publication of our annual report, which we are required to submit to Congress each year on June 30th. And you can imagine we are in the throes of finalizing now. For the first time in a long time, we're exploring one definite theme in our annual report, and you folks will appreciate it. It's backlog and the avalanche effects or snowball effects that the current backlogs have on filers as well as the agency. We're hyper-focused on all backlogs, but there are some impacts beyond just the time lost. That's of great concern to us. We're examining things like how customers can request, expedite, and advance parole, which snowball because of the backlogs. We're taking a deeper dive into one of the worst backlogs of all, the affirmative asylum backlog, and offering some ideas to initiate an approach to operationalizing efficiencies to tackle chipping away at that. We've looked at needed solutions, including digital ones, to encourage the agency to take bolder steps. And we're also trying to give due credit where it's due, such as the approach of dealing with the U-Visa backlog that the agency has undertaken by developing the BFD process. Again, we expect our online submission to Congress on June 30th, so stay tuned. And finally, beyond our annual report, we've succeeded in making 2 additional formal recommendations to USCIS. The first was in March when we submitted a recommendation regarding issuing notices to beneficiaries of Form I-129 petition for a non-immigrant worker, those who are amending, extending, or changing their status so that they have direct notification of actions taken on their petition. And lastly, and very importantly, we submitted our second formal recommendation of 2022. And in that recommendation, we present 5 suggestions for how USCIS may remedy its chronic underfunding through legislative or regulatory actions. As many of you know, USCIS is almost entirely fee funded, and the passage of time from fee review to final rule is lengthy. Relevantly, the current process does not adequately consider the amount of time needed to hire and train staff once a fee increase is adopted, which itself leads to backlogs. We're really hopeful that implementing these recommendations, along with taking a hard look at how CIS's extensive humanitarian work is funded, will help stabilize the agency's funding and allow USCIS to better predict more accurately its caseloads and to direct resources towards timely processing. There's also a bunch of informal recommendations we've made to USCIS this year, and I'm pleased that many of them are going to be reflected in some of the positive actions the agency has taken over the past, and some about which you'll hear about today. There's no question that USCIS Director Jadot is laser focused on how to address the backlog, and we look forward to continuing our work with her and her staff to address this pervasive problem. Thank you for using our office as a channel to raise your questions and concerns and helping us all champion the goal of creating a transparent and accessible immigration process. So with that, let me pass this off to our next presenters, and we get to the substance of our presentation. Nathan, I think it is over to you. Nathan is our Deputy Ombudsman, who will engage in a conversation with Dan, Renaud, and Doug Rand to discuss USCIS backlog reduction efforts. Nathan, the floor is yours.
Great, thanks so much, Phyllis, and thanks again to everyone for joining us today. Dan and Doug, we appreciate the time you both are taking to meet with us to discuss USCIS's backlog reduction effort. So let's get started with some context setting. Dan, can you share with us the extent of the agency's current processing backlog?
Sure. Thank you, Nathan. It's good to be here today. USCIS recognizes the need to adjudicate applications and petitions in a timely manner, and as Phyllis indicated, I want to reassure you that reducing the backlog and processing cases more quickly is the highest priority to the Director Jadot and the rest of the agency. Currently, USCIS has approximately 8.5 million pending cases. Of that total, about 5.2 million are considered to be in the backlog. USCIS defines the backlog as cases exceeding acceptable pending or target levels.
All right, thanks, Dan. So that's some helpful context for framing the issue today. Could you now talk about some of the primary causes of the backlog?
Sure. As you're probably aware, even before COVID-19, backlogs existed due to application and petition receipt increases. USCIS had seen increased receipts for several years, leading to a spike in 2017 that initiated much of the recent backlog growth, as you can see in the chart. As with many other government services, COVID-19 dramatically disrupted USCIS operations in a number of ways and dramatically added to existing backlog. Nationwide closures disrupted interviews for naturalization, lawful permanent residence, and asylum. Additionally, all application support centers were also temporarily closed, and as a result, applications that required biometric submission were paused. After reopening, USCIS implemented social distancing guidelines to protect staff and the public, but those measures significantly reduced production capacity for our interview-dependent work. Complicating matters, because USCIS is primarily fee-funded, COVID-19 initially depressed receipts, which compounded the financial difficulties that the agency was already experiencing prior to the pandemic. One response to the budget shortfalls was a hiring freeze. The agency had to use existing staff to process new incoming applications and petitions, as well as work through the backlog. During the nearly year-long period when the hiring freeze was in place, USCIS was losing capacity due to workforce attrition, even as receipts rebounded to, and in some cases exceeded, pre-COVID-19 levels. As you may have heard, the hiring freeze has since been lifted, and we are working to recruit and hire new staff, but it will take time to return to full staffing levels and to get the newly hired staff fully trained.
Thanks, Dan. We know that USCIS has put in place a number of innovative solutions to address these challenges stemming from the COVID-19 pandemic, and we addressed some of these and highlighted some of these in our 2021 annual report to Congress. But can you share some of these initiatives with everyone on the call today?
Yeah, I'd be happy to. And as I share them, I also want to note that we don't pretend that these are the answers to everything, to all the questions, and we know that we have a lot of work to do. But we hope that you'll see these, and the audience will see these as positive steps, as indicative of kind of where we're going in the future. So I'll highlight a few of those now. To mitigate the effects of backlog capture delay, USCIS has made efforts to reuse biometrics when possible. We've conducted interviews using video interviewing technology and applied creative solutions to ensure social distancing requirements are honored. So even during the pandemic, we were able to, through using video interviews and reusing biometrics, we were able to continue to complete work while ensuring the safety of our staff and the public. Since June of 2020, we've conducted over 160,000 video facilitated interviews where the applicant is present at a USCIS facility but seated in a different office than the interviewing officer. Over 110,000 of these have been for naturalization. Additionally, we've modified our interview criteria to be risk-based, waiving in-person interviews where reasonable and appropriate.
Thanks, Dan. I know it's a significant effort across the agency to implement those new processes. Now, are there also specific staffing or personnel changes USCIS is undertaking to help alleviate the backlog?
Yes, there are. We're making quite a few efforts on that front. We've leveraged congressionally appropriated funding to cover overtime for adjudicators and to hire new staff. It's been a big part of our increase in capacity that we've seen over the last few months. Staffing is a big part of the solution. As I mentioned, the hiring freeze has been lifted, and we're adding staff and focusing allocations on adjudication. Our first round of hiring has favored more towards supervisory roles, which has meant additional internal promotions and an HR infrastructure that's ready to support an increase in new staff. We're glad that we've been able to promote those career civil servants committed to our mission. We're focusing now on hiring additional staff, and we are already beginning to see an increase in the number of new external hires. We plan to hire more than 4,000 employees by the end of this calendar year. While the agency has already announced many promotions on USA Jobs, we also have many more announcements coming out. But we also know that staffing is only part of the solution. The agency also established new cycle time goals to guide the effort of the USCIS workforce. The new national cycle time goals are aggressive but achievable by the end of FY23. Cycle time is an internal management metric that's generally comparable to median processing time. As cycle times decrease, processing times will follow, and applicants and petitioners will get their decisions on cases more quickly. USCIS will be increasing capacity, improving technology, and expanding staffing to achieve these new goals by the end of FY23. The new cycle time goals apply to many of our primary forms and range from 2 weeks to 6 months, as you can see in the slide. For example, applications for adjustment of status, I-485, and for naturalization, N-400, will have a cycle time goal of 6 months, meaning that at the end of FY23, we plan on having only 6 months worth of pending cases awaiting a decision.
That's great to hear, Dan. Thanks so much. And I want to now turn to the policy front. So I'll direct this next question to Doug. Doug, what policy initiatives is USCIS pursuing right now to help achieve its backlog reduction goals?
Thanks so much, and thanks everyone for joining today. I really appreciate your time. A number of things that we've announced publicly in the past couple of months scope review. So in March, Department of Homeland Security published a final rule that aligns the USCIS premium processing regulations with a federal statute and designates additional immigration forms for premium processing services. Specifically, this is ultimately going to expand premium processing, which of course is the ability to pay an extra fee for faster processing within a guaranteed time frame. Ultimately, that's going to include the full measure of I-140 petitioners, that's the immigrant petition for non-citizen workers, that we've already started rolling out. Later this year, we'll also be rolling out a phased implementation of premium processing for Form I-539, which is the application to extend or change non-immigrant status, and the I-765, the application for employment authorization. And of course, it's important to keep in mind that Congress didn't only authorize USCIS to expand premium processing to these categories, but also mandated that we do so in a way that does not slow down anybody who is in the non-premium queues. So we're trying to very deliberately move forward on these things. And I would also add, that premium processing, unfortunately, is not something that can be implemented overnight. It's actual human beings doing the work, and of course, one needs extra human beings to be able to do a faster turnaround time. So we understand and appreciate the fact that a lot of folks out there would be paying for premium processing for a lot of these forms right now if they could. We really want to satisfy that demand. We wish we could, we could just flip a switch and turn it on for everybody, but that's not really operationally possible. We do need to onboard more people, more officers to be dedicated to premium processing, and we are doing that as fast as we can to ensure, outstanding people doing the work. So that's one update. Then, of course, there are a number of policies we've reformed to help ensure that people who have freestanding employment authorization documents that they rely on to work and support their families, face less risk of these things running out, and face lower wait times if they're applying for the first time. So a number of these steps include we have allowed individuals in the healthcare and childcare industries who are renewing their work authorizations to request an expedited review and completion of their employment authorization document renewals. We've increased the work permit validity period to 2 years, originally 1 year, for certain adjustment of status and a number of humanitarian applicants, which means that once one has that document in hand, it's going to last double the time. We've updated our policy so that the spouses of E and L visa holders no longer need to even apply for a work permit in order to work. They can if they want that ID in their pockets, but they are employment authorized incident status, and that is both beneficial for them. It's also beneficial for everyone else because it means that our officers can devote their time to other workflows. We also added spouses of certain H-1B workers to the list of work permit categories eligible for an auto extension in certain circumstances. We weren't able to do it for everybody for a number of regulatory reasons, but about 30% of H-1B spouses, that is H-4 visa holders, who have a standalone work permit are now eligible for the auto extension. And all of these measures reduce the number of employment authorization applications we receive, allowing us to shift our limited resources to other priority areas. One more thing I wanted to mention is that last month we announced the temporary final rule, also known as a TFR, that increases the automatic extension period for employment authorization documents for certain renewal applicants up to 540 days, which used to be 180 days. So that increase in the auto extension period became effective on May 4th. It's going to help avoid gaps in employment for all those non-citizens with pending renewal applications. and stabilize continuity of operations for U.S. employers. Why was that necessary? Well, despite what I've seen firsthand were extraordinary efforts of the USCIS workforce to address our pending EAD work permit caseload, as well as implementing all those policies I just mentioned, the agency determined that the 180-day automatic extension is currently insufficient. Many of the non-citizens with lapsed 180-day automatic extensions and expired work permits are those most vulnerable, seeking protections in the United States with already precarious economic situations. And so we determined that this rule is necessary to ensure that that as many people as possible do not see their work permits expire through no fault of their own. So just to be really clear, this temporary final rule applies to about 2/3 of those who have pending work permit renewals. That includes asylum applicants, adjustment of status applicants, suspension of deportation and cancellation of removal individuals, current asylum and refugee, TPS beneficiaries, and most other work permit categories. But it does not apply to DACA beneficiaries, students, certain H-4 spouses, about 70% of H-4 spouses, the ones who don't have the standalone work permits that I mentioned earlier, and other small work permit categories. That's not an arbitrary, dividing line between the two. That's just, by regulation, the kinds of work permit categories where we can and cannot currently make folks eligible for the auto extension. If you are eligible for the auto extension, meaning you file for work permit renewal before that work permit expires, then there's 3 scenarios. Non-citizens with a pending work permit renewal application whose 180-day automatic extension had lapsed and whose EAD had expired. In that case, your employment authorization was restored and extended as of May 4th and will last up to 540 days from the expiration date of the work permit. If you're a non-citizen with a pending renewal application that's still covered under the previous 180-day automatic extension, then your unemployment authorization will be extended as of May 4th for up to 540 days past the expiration of the EAD. And for those who are going to file a timely employment authorization document renewal application between May 4th and October 27th, 2023, those individuals will be granted an automatic extension of up to 540 days, just by virtue of applying. For more information on this, please see our dedicated website, which is uscis.gov/EAD-AutoExtend, and it's available in multiple languages so that folks can make sure they understand what applies to them and how to talk to their employers about their work authorization. I feel like I've been talking for a while, but there's one other thing I want to at least touch on, which is the use of employment-based immigrant visas in this fiscal year, which we know is a really urgent issue for a lot of people who have been waiting in the queues for a very long time. So let me just go over this quickly. Under our immigration laws, it's possible for unused employment-based visas to be permanently lost at the end of the fiscal year. That would be September 30th of this year. Normally, that is very rare. However, there was an unusual scenario due to the COVID-19 pandemic where consular facilities around the world shut down and were not able to process their usual load of family-based visas over the past couple of years. And so that has caused, in FY21, more than 104,000 of those unused family-based visas became employment-based visas. And that's on top of the 140,000 already set aside by law. And then in this fiscal year, we're seeing the highest ever. We're seeing basically double that 140,000 number being allocated to employment-based immigrant visas. So that's a major undertaking to get through all of them. We were able to get through most of them last fiscal year, but did leave several immigrant visas unused at the end of the last fiscal year. But the obstacles we removed last year make us well positioned to achieve use of all of the available visas this year. We've taken a number of steps to limit the number of visas that go unused at the end of this fiscal year. We can get into more of that later if we have time. But for now, I would say, just last week, USCIS posted a detailed FAQ for those who want to learn more about how to, how our agency is treating this surplus of employment-based visas, how we're going about trying to make sure they all get utilized, and the steps that individuals can take to work with us to try to make sure we're able to work those cases quickly. So, for example, if you haven't yet, if you've applied for a green card or adjustment of status, I should say, and you have a visa number available and you have a petition approved, then you're in the sweet spot for this fiscal year. If you haven't yet submitted your medicals, though, please don't send them to us unsolicited. Please wait for a request for evidence and then get them in the mail immediately. If you don't already have medicals, it would be a good idea to go out and visit a civil surgeon, use the USCIS Find a Doctor tool, go get those medical forms ready right away so that, if hopefully within the next 3 months or so, you get that request from USCIS to submit your medicals, you've got them all ready, and you can do so and turn that around immediately. We give our officers the maximum amount of time to work your case and come to an answer. So I think I'll close with those details. There's a lot we're doing. Hopefully that's clear. We understand there's a lot more we need to do, and appreciate everyone joining today to hear the latest. So thanks again, and I'll send it back to you now, Nathan.
Doug, thank you. No, I think you touched on the topics we're certainly hearing about here in the CIS Ombudsman's office, and I did want to mention too, I'm glad you talked about the frequently asked questions you all just posted. We also sent a stakeholder message out earlier today highlighting that information as well, along with some other details about employment-based adjustment applications that we hope the stakeholder community will find very helpful. You covered a lot there, Doug, and it really does appear and it looks like the agency is making some significant strides in the policy and procedural arenas. And we do appreciate the fact too that the agency has implemented several policy recommendations that have come from our office. We do value our collaborative efforts with USCIS, and we're going to continue on our side looking for additional ways to increase efficiencies of the agency. I did want to move along now and touch on technology and leveraging technology to complete work. I know from our perspective here in the CIS Ombudsman's office has never been more important. And I know the agency has been looking at a lot of technological solutions as well. So Dan, can you talk a bit about how USCIS is using technology as part of its backlog reduction efforts?
I sure can, Nathan, and you're right. Technological innovation is a key piece of our efforts to address the backlog. As I mentioned earlier, we launched video interviewing processes where interviews were conducted at a USCIS facility with the adjudicator and applicant in separate rooms connected via video conference. We've undertaken a number of efforts aimed at improving operational efficiency. Those include transitioning some pre and post non-adjudicative work to non-adjudicators to free up adjudicators to make decisions on cases. We've centralized delivery of information services through the USCIS contact center and website. And again, that was aimed at increasing capacity by reassigning officers who were previously answering routine questions that could be answered through the contact center, and instead having them adjudicate cases, make decisions. We are leveraging electronic processing and streamlining. What that means is essentially replacing some of the ministerial work that officers do during the adjudicative process, some of the validation, checking systems, those kind of things. And we're having our systems now present that information or do that validation for the officer, again, increasing our capacity, freeing up adjudicator time. We're monitoring workloads to reprioritize and redistribute resources when necessary. And as I mentioned earlier, with respect to video interviewing, we have begun to conduct remote office-to-office video interviews where the applicant is in one office, one field office, for example, and the adjudicating officer is in another office. And that allows us to balance workloads, especially in field operations, to make sure that our customers are having a similar experience in terms of wait time, or at least a more similar experience in terms of wait time on how long it takes to adjudicate, for example, a 485 or an M400. We continue to look for opportunities to leverage digitization of evidence and data and increase technological sophistication to allow us to adjudicate more efficiently and make the most out of our officer resources. Essentially, we need to build capacity. There are three ways to do it. We can do it through process and policy modifications, which Doug just went through a number of the things that we've done. We can do it through increasing staffing and overtime, which we are working on. I talked about the hiring initiative. I talked about the funding we're using for overtime, and we can do it through technology. And we certainly are not ignoring kind of the third leg of that stool. Back to you, Nathan.
Thanks. Yeah, no, thanks, Dan. And I think that's a good way to really categorize the efforts, and it's really great to hear on our side about all the work currently underway at the agency to address existing backlog. I want to look forward now. So, looking into the future, can you share anything about efforts that the agency envisions to further reduce the backlog, some of the things maybe you're thinking about or beginning to implement here in the near future?
Yeah, absolutely. First, we are committed to continuing the hiring initiative to combat staffing and resource losses that we experienced during the height of the pandemic and during our hiring freeze. That is a centerpiece to our backlog elimination effort. We simply need to increase capacity, and one way to do that is to get more arms and legs on duty, making decisions on cases, and also those positions that support those activities. Additionally, as you know, the FY22 budget included $275 million in appropriated funding to address backlogs at USCIS, and the President's FY23 budget calls for continued appropriations to fund backlog staff and work. In addition, we've developed several longer-term strategies to include identifying and implementing greater efficiencies in our processes and streamlining existing processes to speed up adjudications without sacrificing integrity. Again, this combines both process and technology. Digitizing files and increasing the number of applications and petitions that can be filed online will help to achieve efficiencies, as adjudications will not be delayed due to the need for physical file movement, which is hampering some of our activities right now, moving cases from office to office in order to get paper in front of an adjudicating officer. Digitized files will facilitate easier reassignment, so when we need to balance the workloads, it can be done without having to box up and send those files. We're also simplifying and improving how we communicate case processing time data publicly. In May, we announced a series of improvements to our website that give applicants more detailed and user-friendly information to help estimate how long it is likely to take USCIS to process an application or petition. With all these initiatives and those that we'll consider in the future, we will seek to get to the right decision more efficiently on every pending case, while achieving even greater integrity throughout the immigration system. Together, these measures put USCIS in a strong position to build up our resources and staff needed to ensure that we keep up with incoming work and continue the modernization effort. These are just a start of what we're doing. We have other initiatives and ideas planned, and we're working internally to make sure that they are calibrated right, that they're rolled out right in a safe, secure, and smart way. But our goal, as echoed many times by our director, is to increase capacity and in turn to reduce the backlog and improve processing time. And with that, I'll pass it back to you, Nick. Thank you.
Thanks so much, Dan. And it's great to see the commitment really at every level of the agency. I want to thank you and Doug, and really appreciate the time that you've both taken today to provide us with an inside look at all the work USCIS is doing around backlog reduction. Now I'm going to change it up and hand it over to Alyssa McGovern, our Chief of Policy here in the CIS Ombudsman's office. Alyssa will facilitate the listening session portion of the engagement. Alyssa, I'm turning the microphone over to you.
Thank you, Nathan, and thank you again to our speakers who are sharing of their time and expertise today. We have received a lot of questions and comments in the chat. Please continue to add to that. That will all be shared with our speakers later if I don't share it right now. And we will do our best to cover as many topics as we can, but we'd like to hear from you. This is really a chance for you to provide your input. And this, we are not asking our speakers to answer questions right off the top of the bat here, but we are asking them to take away what you have to say. So please, feel free to continue to ask your question in the chat box, but if you'd like to ask your question by phone, we'll give you those instructions in just about 10 seconds. We do have a few questions that we will ask that have come through today that, to get your thoughts moving and to help facilitate the discussion. So as I said, following today's engagement, we do plan on sharing your ideas and suggestions to reduce backlogs and processing delays with the agency, so please share with us. Bridget, could you please share the instructions to share information or ask a question by phone?
Thank you very much. We do welcome all questions or comments. To register, please press the 1 followed by the 4 on your telephone. You will hear a 3-tone prompt to register your request. If your question has been answered or you would like to withdraw a registration, please press 1-3. Again, we do welcome all questions or comments. To register, please press 1-4 on your telephone. One moment, please, for the first question.
Thank you, Bridget. And while we're waiting, I'm going to ask some of the things that have come up already in the chat box. So we appreciate that. Dan, you said you were prioritizing product lines. What product lines are you currently prioritizing?
So if we could turn again to, I think it was slide 10, you'll see the new cycle time goals. The agency has identified these workloads as some of our highest volume workloads as areas where we are going to where we have set FY23 processing time goals. These are not our ultimate processing time goals. Those remain unchanged from what was published in the Federal Register a number of years ago. These are the interim goals that we plan to hit by the end of FY23. And again, this is probably about 80% of our workload. These are aggressive, we think, but achievable. When we set these goals back in March, we knew that we did not have capacity at that time to complete these goals unless some things changed. And those changes are reflected in an increase in staffing, in technological changes, and in changes that some of which Doug mentioned in the policies and procedures. We believe that we are on course to meet these goals or exceed them in many areas. This is not the responsibility of the 6,000 or so adjudicators. This is the responsibility and the commitment of the entire agency.
Thank you, Dan.
Welcome.
This case has come up quite a bit. Do you have a current backlog in retrieving A files from the National Records Center?
Oh, I guess I'll take that one also. So the USCIS National Records Center is responsible for the storage and in its NRC facility or with a private contractor. 8 files that are inactive and not expected to be requested in the near term are stored with the National Archives and Record Administration, NARA, in its Federal Records Center, with the vast majority of files being stored in Kansas City. This includes a large majority of files that may be requested for naturalization adjudication. Before the pandemic, there was no backlog in file requests from the NARA Federal Records Center. However, due to operating restrictions in the Kansas City Federal Records Center during the pandemic, a backlog of file requests had occurred, and we stopped actually transferring files to the FRC in March. We have worked with NARA and the individual federal record centers and have alleviated the backlog that they experienced in returning files to us. As of March 28th, all Kansas City FRCs have returned to 100% operational capacity, and they've also brought on additional contractor support. So we, at current production levels, USCIS expects to have eliminated the file retrieval backlog in its entirety by July of 2022. Many of those primarily naturalization cases that were kind of stuck in this file retrieval backlog have already been interviewed. Many have been naturalized already. So we should, if people are not seeing those cases move already, they should very, very soon. We are glad that is nearly complete. You're welcome.
So we've heard a lot about that. But I will say there is one issue that we have heard about in the chat box more than any other today. And so I'm going to actually turn the microphone over to Doug on this one, which is, do you think it will be possible to grant all of the available employment-based visas this fiscal year?
Yes, we do think it's possible. We're working hard to achieve that goal. Just to review, the Department of State currently estimates the annual limit for employment-based immigrant visas for this fiscal year, FY 2022, will be approximately 280,000, which is double the typical annual total. And that's due to unused standard-based visa numbers from FY 2021 falling across to the current fiscal year per how Congress set this up decades ago. So as of mid-June, this month, USCIS and the State Department have used significantly more visas. By used, I mean, approved cases. Significantly more visas than at the same point last fiscal year. And USCIS alone has utilized more than twice as many visas on a weekly basis than we had at this point last fiscal year. So as a result, we believe we're well positioned to use all of the available employment-based immigrant visas this fiscal year, despite that higher annual limit. And again, I would encourage everybody to check out those FAQs that we published last week and bookmark it, because we're going to continually update those FAQs based on stakeholder feedback that we get, because we want everyone to have details and understanding as we can reasonably provide the work we're doing and what people should and shouldn't do to get their applications in order this fiscal year.
Thank you, Doug. To continue on that quickly, Dan, in February, USCIS encouraged the transfer of the underlying basis of adjustment of status applications from EB3 to EB2 or even EB1. How is USCIS ensuring that these transfer requests are effectively processed on time?
I can take this one as well. Again, on our website, you'll find all the details of this new process that we established several months ago, dedicating a single mailing address at the Western Forum Center for receiving written requests from employment-based adjustment of status applicants who want to transfer their pending adjustment applications to a different employment-based category where there's a visa available. This new process provides centralized filing location and allows USCIS on the back end to electronically distribute these transfer requests to just the right office or service center where that case is located. So we are set up to provide a confirmation of receipt when one submits a supplement J. Not everybody has to submit a supplement J. Some people only need to submit a written request. We are not set up, unfortunately, to provide a receipt confirmation of those standalone written requests. But please do rest assured that if you have submitted a transfer of underlying basis, that we are working your case through the process, and you will you should see updates in the near future. I want to emphasize that sending more than one written request to transfer the underlying basis does create additional work for our already strained mailrooms and record staff. Doing so will not impact the individual's case processing time, but it would create additional and unnecessary resources and could slow down the system for everyone.
Thanks, Doug. Thank you. That's a very important point. With that, I'm going to ask our listeners to give us some of their feedback. Bridget, can we have the first caller, please?
Thank you. Our first question comes from the line of Arnab Song. Please proceed with your question.
Yeah, hi. Thank you very much. So first of all, I'd like to thank everybody for their services, and to all of us, thank you very much. So my question is, I filed my case in April. I'm a straight DB2 case. My priority date is probably June 11, 2014. So what are my chances of getting the visa allocated before September 30th? Thank you.
Thank you. Unfortunately, we cannot answer case-specific questions today. And really, we're trying to get your feedback to hear some of your ideas, where you're seeing things and where you think the agency should be focused on some of the things. So we'd like to go to the next caller, operator, if that's okay?
Yeah.
Of course. Thank you. Our next question or comment comes from the line of Ron Sandor. Please proceed with your question.
Hello. Thank you very much for your this important meeting that you've given all of us today. It's rare that a large group of individuals in a bureaucracy do this, and I appreciate it. My question is regarding our own application that's at NBC. Forms were requested electronically 7 months ago, and we returned the answer to the forms within the hour. We've asked electronically if they've received the forms, got no reply. We've phoned the numbers that are offered, we've got no reply. And we kind of feel in limbo right now because we don't know what's going on. And you touched upon that earlier. I'm sure a lot of other people are feeling a little lost. But in our own case, the forms that were asked, they already had. So we sent them in a second time. One of them was completely bogus. So I don't want you to answer the specific thing, but who do you reach out to when you're stuck like this? Thank you.
Thank you. That's actually a very interesting question, and that's exactly one of the reasons why the CIS Ombudsman's office exists. If you think if you're stuck and you fit into the criteria that we can, of the services that we can provide, which are on our website, by all means, we have a very short form that we ask you to fill out. But by doing so, we can see if we can assist you. If we can't, we'll tell you. But if we can, we'll do our very best to try to at least make sure that the case is where you think it is and that it's still being adjudicated. And we don't let go until we know for sure that things have resolved. So that's very good. Yeah. It's a very good question. Thank you for that feedback. Okay. I'd like to take the next caller and get some more feedback, please. Thank you.
And our next question comes from the line of Punit Agrawal. Please proceed with your question.
So my question is, the USCIS should concentrate on the I-140, which was filed in October 2020. There are thousands of cases which is pending only for the I-140. It's like I'm one of them, and due to that, be able to transfer based on the debt transfer under the there are some terms UV, right? So I think USA should concentrate on I-140 so that people can transfer their green card from EB3 to EB2. That's my feedback to the USA because everybody is stuck over there.
Thank you for that feedback. That is also something that's come here on the chat box. So we appreciate that.
Yes.
Operator, next caller, please.
Thank you. Our next caller is Saurabh Pradhan. Please proceed.
Hi. First of all, thanks for this engagement. This is really helpful. I have a question that is on the minds of thousands of people, to be honest. So, USCIS announced in February that AOS cases that are not yet worked on and that have not been RFP'd will be transferred from Lincoln and the Texas Service Center to the National Benefit Center. And we did see thousands of cases get transferred from the Texas Service Center to NBC, but we are seeing a stark difference in the pattern between how the Texas cases are being transferred versus in Nebraska. Nebraska, we are seeing only a few cases transferred per day. And the question that's on everybody's mind and that's getting everyone anxious is this happening based on priority dates, based on the interfiling dates to the new Montclair address, or is there some other criteria? Because many people are also filing duplicate cases because they are scared that their case is not going to get transferred and get a visa this year.
Thank you. Again, I'm going to repeat, we're really unable to answer questions.
No, I want to jump in because I do think this does implicate some systemic questions. We understand and appreciate the concern people have. We want to do more to alleviate that. We are moving cases as quickly as we can from the service centers, onward to the National Benefit Center and the field offices as appropriate. We've moved tens of thousands of them already, and more movement should be seen in the very near future. I want to emphasize something that we've said before and we'll say again, which is filing an additional redundant I-485 is not something we want to encourage. It does not result in faster case processing for any individual, and it taxes the whole system more. So that we understand why people are feeling really like they want that extra security, but it's not something that should be done. And for our part, we know that the best remedy would be to make it as clear as possible that these cases are moving forward to ease folks' anxiety. So please keep an eye out, and we'll hopefully have even more numbers to show in terms of that moving cases from the service centers, so that people can see that and be more confident that their cases are moving forward.
Thank you.
Thank you, Doug. Appreciate that. We're now closing in on 2 p.m. Eastern. Before we wrap up, I would like to say thank you once again to Dan Renaud and Doug Rand for joining us today. We very much appreciate the time you spent with us this afternoon, as well as the information that you've provided. I also want to thank our listeners for the feedback that you've shared. Please note that we will share your ideas and suggestions to help reduce case processing backlog with our USCIS colleagues. And not just Doug and Dan, trust me, we'll share them with everybody who will listen. Bertha, I will turn it back over to you to conclude today's engagement.
Thanks, Elisa, and a big thank you to all the speakers and participants who joined today's webinar. Just a reminder that if you haven't subscribed to receive our event notifications, please follow the link that we are making available on the screen for this webinar. For your awareness, we are providing links to all the content that was covered in today's engagement. You should be able to see the information on the screen. Also, as I mentioned at the beginning of the engagement, we will be posting a summary on materials from today's webinar on our webpage in the next few days, so stay tuned for that. If you need to email the CIS Ombudsman regarding a case assistance request, the email address is cisombudsman@hq.dhs.gov. For information relating to stakeholder engagement, the email address is cisombudsman.publicaffairs@hq.dhs.gov. We have expanded our outreach efforts to have social media presence, and we are now on Facebook and LinkedIn. So please take a moment to visit our pages and click the like or follow to ensure you see all of our posts. And similarly, we encourage you to visit our outreach page at www.dhs.gov/outreach to find invitations to our upcoming webinars, read summaries of previous engagements, and to take our CIS Ombudsman Customer Satisfaction Survey. This concludes today's webinar. Thank you so much and have a great day.
Thank you, everyone. That does conclude today's presentation. We do thank you for your participation and ask that you please disconnect your line. Have a great rest of the day, everyone.